Well, hello everyone. We should be making a start now. Welcome to the webinar today on parental bereavement leave and pay. So, thank you very much for joining us today, firstly. We shall begin just by introducing ourselves, if we may, just so you know who you are listening to. So, my name's Karen. I am the HR Knowledge Manager for HR Solutions, and I'm going to be the lead presenter on this webinar today. And I am joined by my colleague Atim, who is here to field any technical problems if you should have any throughout this live session. Hopefully, of course, there won't be any, but please do send her a message if you do, and she'll try and help. Also, as we go, if you should have any questions, please do send them through to her. She'll be monitoring and collating those, and will pass them to me at the end. And I will look to get back to you directly after the session as soon as I possibly can. So please do give us a message if there's anything you would like to ask or anything we can help you with. We are recording this session, so you will be able to watch this again, and you can share it with your colleagues as well, of course, if you would like to. And again, as we normally do, we will make a copy of the slide deck available on request if you should like a copy of those. So please do let us know if that would be helpful. All right, so that's us. Let's have a look at what we are going to be covering today. So in this session, I'm going to begin by giving you a little bit of an overview of this new law that we have. We're going to look at eligibility, entitlement, protections and rights that are also going to be afforded, existing legal considerations, and we'll have a quick look at how we can implement these new provisions into our practices and policies as well. So just a few aims. Hopefully, by the end of this webinar, you'll feel that your awareness has been increased a bit with regards to the new statutory rights for bereavement leave and pay. That you will also understand a little better the scope of what future processes may look like. Be reminded of the important factors that must be considered currently for any bereavement leave. And hopefully you'll also feel a little bit more comfortable with affecting the upcoming changes into your current practices. And I hope I can put your mind at rest with regards to that. So there we are. It leaves us to begin with the overview of the topic for today. So it, of course, goes without saying, I think, that the death of a child is one of the worst experiences a person could probably go through. Most employers are compassionate and flexible at such a devastating time, but sadly, it is not always the case. In other situations, it might just be that employers are simply unsure of what they should or what they can offer to support their employee. So this leaves us to look at what the situation currently and technically is. Well, currently there is no specific right to time off for bereavement whatsoever. A while back, about a year or so ago, a public consultation was launched by the government, and the purpose of it was to discuss the introduction of a statutory minimum bereavement leave for parents specifically who have lost a child. Now, the consultation invited views of members of the public, so parents who have had to go through this situation, other parents, employers and interested parties, to find out what they thought arrangements should be, okay, what arrangements should be made and how these should be implemented in law. And following this, in September of last year, the Parental Bereavement Bill was given royal assent, okay, and became the Parental Bereavement Leave and Pay Act 2018. So this is a piece of legislation that is in place. However, Regulations are still to follow, okay? So an additional piece of law is still to follow, and we refer to this as a regulation, and that is going to detail more fully how this Act, how the Parental Bereavement Leave and Pay Act should operate, okay? Because we are still waiting for these regulations, the Act itself is not expected to be enforced on employers until April 2020, okay? But it could be sooner because this Act, what was a bill, has moved through the legal process fairly quickly. So we may as well be ready to make arrangements for it. So to give you a snapshot, quick look, the new law introduces a right for employed parents to be absent from work for a minimum period of time, okay, and that's going to be 2 weeks at least, following the death of a child. Now, eligibility criteria and various conditions will determine whether parents are entitled to this leave and whether or not they are also entitled to pay. Now, in addition to leave and pay, parents taking bereavement leave will be afforded employment protections, okay, and these will be similar to those associated with other forms of family-related leave. So you've had a snapshot there. I don't know what you think about those and what's being introduced. You may think it's not a lot. You may think that it's quite good, considering there isn't anything at all at the moment. But this new allowance is actually going to be one of the most generous statutory arrangements for bereaved working parents in the world. Okay, and the estimated cost of the new statutory payments is expected to be between 1.3 million and £2 million in the UK each year. Okay, so let's have a look at who would be eligible and when. So we'll start with statutory parental bereavement leave, okay? So first and foremost, the employment status of the individual must be that of an employee, okay? Parents who are technically workers are not going to be able to have this leave afforded to them. And also anybody who provides the contract for service, which basically means are self-employed, is also not entitled to this leave, okay? So it's only something that employees have a statutory entitlement to. There will be no minimum length of service required to be entitled to this leave, okay? So this is going to become one of those day one rights, meaning there is no minimum length of service required whatsoever to be entitled to this type of leave from work. So as soon as you employ somebody and they have come into work, they are entitled to this leave if such circumstances should arise. Now, they also need to meet the following definitions, okay? And these are definitions which apply to them as individuals and also to the child who has passed away, okay? So to be eligible for parental bereavement leave, the person must fit the definition of a bereaved parent. Now, the Act says that this will be an individual who is defined by regulations, okay? So they would have to satisfy prescribed conditions in the regulations which are still to follow regarding their relationship to the child who has died, okay? Now, this may be framed in whole or in part by reference to the care of the child before their death. So it's my view that not having a simple definition for a parent is a good thing, really. The reference that we have here to the care of a child suggests to me that consideration is being taken because there are, of course, all kinds of family arrangements to be considered. You know, often grandparents become main guardians, there are foster parents, children living with aunties and uncles or friends of relatives. There are step parents, you know, those who would effectively be step parents if they were married or had a civil partnership to the biological parent, you know, and so on. There are so many different types of relationships that people might have with a child based on the nature of the care that they give. So I think it's a good thing that there is going to be quite a broad scope to encompass a broad array of possible relationships where somebody could be deeply affected by this situation. We also have the definition of a child then. So this is a more simple definition. It means a person under 18 years of age, okay, in the context of parental bereavement leave. Now this will also include a child who is stillborn after 24 weeks of pregnancy, okay. So this mirrors entitlements that we have on maternity leave in that situation as well, which we'll actually discuss a little bit later on. So, looking now at eligibility for pay. Entitlement to pay will be conditional, firstly upon the employee being entitled to leave, and that may sound a little bit obvious, but being a piece of law, it has to be, of course, all-encompassing and cover all. So that means that all of the eligibility criteria that we've listed previously for leave would have to apply before the person is also entitled to pay. The employee must have 26 weeks continuous service to be entitled to pay, okay? So leave is a day one right, but pay requires at least 26 weeks service, and that's calendar weeks, okay, ending with what's called the relevant week, okay. So we're talking about 26 weeks minimum. The employee must have continued to be employed after that point up until the child passes away. So we're talking about a minimum of 26 weeks service, but somebody must be continuously employed from that point onwards, okay? And the relevant week means the week immediately before the one in which the child dies, okay? And when we're talking about a week, we're talking about a calendar week, so 7 days, rather than, say, a prorated week for somebody who might be part-time. We also have to consider their earnings. So the employee's normal weekly earnings for the period of 8 weeks, ending with that relevant week, must not be less than the lower earnings limit in force at the time. Okay, and I believe it's currently £116 a week at the moment. So if this were enforced now, somebody's earnings for the last 8 weeks, ending with that relevant week, must be at least £116 per week or more, and then they would be eligible for the new statutory payment. And a bereaved parent would only technically be entitled to payments if they provide notice to whoever is liable for the pay, stating the week or weeks which the payment should be made in respect of. Okay, now regulations, as I say, that are still to come, may detail what time frame within which that notice must be given. You know, I'm sure most employers will be fairly lenient with regards to that, but of course the line has to be drawn somewhere. So we expect regulations to give us a time frame on that notice, and employers will be able to require that that notice is given in writing if they should wish to. That's pretty much it, but further rules may still be imposed by the Secretary of State with regards to pay. Okay, so it's likely, well, they're able, I should say, to make provisions regarding things such as evidence of entitlement, the amounts earned under separate contracts, and whether or not that can total be added together to create the average earnings that's required to be eligible. And also how earnings should be calculated and various other nuances and things like that. So we do just still need to keep our ears to the ground a little bit for those regulations too. So entitlement. Going back to leave again, a bereaved parent would be entitled to a minimum of 2 weeks leave from work, as I mentioned earlier. Okay, now this leave must be taken before the end of a period of 56 days. Okay, and that period begins on the date of the child's death. And this period is going to be known as the qualifying period. Now, in the event that an employee should tragically become eligible due to the death of more than one child, then the employee is entitled to leave in respect of each child. Okay, so they would be entitled to 4 weeks leave from work. Now looking at pay, so of course this creates a brand new statutory payment, and it is known as the statutory parental bereavement pay. Now the amount will be payable in respect of the prescribed number of weeks, okay, which of course is going to be at least 2, and only those weeks which are taken within that qualifying period that I mentioned previously. Okay, now it may be the case that statutory pay can be paid in respect of non-consecutive periods, so taken in week blocks, for example, similarly to paternity leave. You know, so we can give a new father 2 weeks leave. They can choose to take 1 week, return to work for a short period, and then take another week if they wish. So that may be the case here. Again, if it should be that an employee becomes eligible due to the death of more than one child, they would be entitled to pay in respect of each child. So talking about pay, let's look at how much we're talking about then. Well, the Act says that these regulations, which we should have soon hopefully, can determine whether the rate will be a fixed payment. Okay, so for example, the normal statutory rate is currently £145.18 per week, you know, for maternity or paternity or adoption leave. That's the statutory rate. Or it could be a weekly earnings related rate. So as another example, let's use maternity. You know, the first 6 weeks of statutory maternity pay are currently 90% of average weekly earnings. Okay, so it will be either that flat rate or an earnings related rate. Thinking about back of house and you know, how this is going to be operated through your payroll. If hypothetically you were to have any contractual pay that is due to an employee over this time, so let's say you create your own contractual policy to pay a certain amount over a period such as this, then any contractual pay you offer over this period, okay, that you choose to offer over this period, will count toward the requirement to pay statutory parental bereavement pay, okay, and vice versa. So just to give you an example of what this means, you know, if statutory parental bereavement pay was this flat rate of £145.18 per week, and let's say you have a contractual policy to pay £200 a week for each week of parental bereavement leave, then the employee would be entitled to the £200 per week only, okay, depending on the wording. They would not be entitled to the £145.18 plus £200, okay, and this works the other way as well. So it's also expected that small employers will be able to recover the cost of the statutory payments, all right, and larger employers are going to probably be able to reclaim most of this pay. So let's have a little look now then at protections and rights that will be afforded to parents in this circumstance. There are a few, probably fairly similar to those that you're familiar with already with existing types of parental leave. So firstly, there will be the right to benefit from the same terms and conditions of employment, okay? So these are the same terms and conditions, including non-contractual terms, that the employee would have had but for the absence, okay? However, any terms and conditions that relate to remuneration are not afforded that same protection, okay, which stands to reason because, of course, there is this new pay element that would be attracted to this type of leave. The upcoming regulations may set out what is and is not going to be regarded as remuneration in this circumstance. In the same vein then, employees shall also remain bound by those terms and conditions of employment, okay, except insofar as they should be inconsistent with the rights and entitlements that should be afforded under this Act and the associated regulations. Following the leave, employees will be entitled to return to a job, okay? So that's as much as the Act currently says. The specifics of what that means are going to be defined by the upcoming regulations. I think it's likely we can expect this to be akin to what we know now with things like maternity and paternity leave, you know, so particularly for maternity, we understand that employees have the right to return to the same job or one without detriment in terms, okay, if they return in the first 26 weeks. So it's likely something similar is going to apply in this circumstance. Now, the Act specifically says that any employee benefit schemes that you may operate must be fair in terms of their provisions, okay? So this may require you to review existing benefit schemes and check that in the hypothetical situation that you have an employee who needs to take this type of leave, that they would not be treated less fairly than if they hadn't have had that leave. Otherwise, the scheme may not comply with the principle of equal treatment that is required. Okay, so it may be that we need to just review benefit schemes and check that there is not going to be any issues there. We also have specific discussion on redundancy and unfair dismissal. So it's expected that the regulations will implement quite specific protections surrounding redundancy situations and other forms of dismissal during a period of statutory parental bereavement leave. So, for example, the requirement to offer alternative employment in a redundancy situation, and also the potential to treat a related dismissal as automatically unfair. If there should be any clauses in a contract, any agreement, or any other sort of undertaking that an employee might have been asked to sign, which has an element to it which attempts to exclude or limit the employer's obligations to make statutory payments or any other obligations under this law, then that that agreement will be automatically void, okay, by default. As an example, and this is an example specifically given in the Act, if an agreement were to require an employee to supplement the cost incurred by the statutory payments, for example, and the employer would have paid the other part, that sort of agreement would automatically be void and unenforceable. Now, rights and protections will also apply where there has been a continuous period of absence, which is partly attributable to any other statutory family leave, okay? For example, maternity leave or shared parental leave. Now, all this really means is that if an employee were to take bereavement leave, and highly likely that this would be because of a newborn, but if they were to then immediately go into shared parental leave or maternity leave, okay, then their rights and protections would be carried over. Their rights and protections would not be lost simply because the bereavement leave sat immediately alongside the other type of family leave that was taken, okay. So this might seem like the sort of thing we would expect to be a given, but again, the law must encompass every scenario, and so it applies that protection and coverall for that scenario too. So the Act also allows for the regulations that are to follow to make some further provisions, okay? And so these are the sorts of things that we can expect, okay? So there could be further provisions about notice that's required to be given, evidence to be produced, and other procedures for both employers and employees to follow. It can also make provisions about the requirement on employers to keep records, okay, of the amount of leave that is taken. Consequences of failing to give notice or evidence or to follow procedures. Further consequences about failing to act if notice is given to you. Provisions for any consequences where a right corresponds with these rights or arises under the contract of employment. So if there's any conflict anywhere under a contract of employment or other rights, provisions need to be made to accommodate that. And similarly, any amendments or provisions that would need to be made to other acts of law in order to enable these rights that we've discussed to be afforded to people. Okay, so that is the new law and what it scopes out for bereavement leave to look like. And so it really enables employers and HR people to also scope out new policies, new practices and letters and so on. As we prepare to do that, we've also got to bear in mind existing obligations. As this is going to impact on what we must organise and will inform our approach as well, okay? And I think as this is a topic that is not really regularly discussed, it is well worth us revisiting these aspects now. So let's take a look at existing legal considerations that we have. So Let's think about time off for dependents. Now, many of you may be aware that in the Employment Rights Act, individuals are entitled, or employees, I should say, are entitled to unpaid time off for dependents, which of course can include a child. Now, this type of leave permits an employee to take a reasonable amount of time off during working hours, solely to take action which is necessary in prescribed circumstances. Okay, and one of these prescribed circumstances is in consequence of the death of a dependent, which is not something we usually think about when we think about time off for dependents, but that is specified in the Employment Rights Act. Now, in this circumstance, under time off for dependents, the type of leave is designed to allow time off to make funeral arrangements or to attend the funeral and to sort out similar matters. Okay, what it is not is time off to deal with the emotional effects of bereavement, and we do have case law on that. So this is something that we have currently. You know, the right to time off for dependents is also limited in its definition of the relationship that must exist between an employee and a child, okay, in the circumstances of a death. Now, many of us are used to thinking that for the purpose of time off for dependents, a dependent can be anyone who relies on our employee for care or for the provision of arrangements for care. And that is true in most day-to-day circumstances, but it's only true for specific circumstances that the Act sets out, and it does not apply in the circumstances of a death. Okay, so who a dependent is in the Act is very limited. It simply says a child, and as we have discussed earlier, the new Parental Bereavement Act is going to be much broader in terms of who a bereaved parent can be. So the new Act brings with it a much broader scope than what we currently have to deal with at the moment in law. We have to talk about maternity leave, really. If a female employee were to have a baby currently, who is stillborn after the 24th week of pregnancy, the employee is entitled to receive the full 52 weeks of maternity leave. If she were to have that baby before 22 weeks and it was born alive, but subsequently passed away, she would also be entitled to the full 52 weeks maternity leave in that scenario. Now, the effect of this is to create a type of compassionate leave, you might think, but of course this is limited as it is only for mothers of some new babies. Discrimination is another legal consideration. It is important to consider possible discrimination issues when considering how to handle any requests for time off for bereavement. And I'll give you a for instance. The Equality Act 2010, of course, protects individuals from discrimination, and one of those characteristics which is protected is religion or belief. Now, it's going to be important to try and accommodate religious customs, which might require specific practices relating to funerals and periods of mourning. Okay. Another example that I wanted to give includes mental health difficulties. Okay. So if we think about things like post-traumatic stress disorder, depression, you know, things which may well arise or even worsen because of bereavement, may be protected as a disability. Okay, now this scenario may also require an employer to make reasonable adjustments to support the employee with work, okay, and their duties. So considerations such as these are part of the reason why time off for bereavement is normally reviewed on a case-by-case basis. Now, this one may not spring to mind as immediately obvious, but we also do need to think about health and safety, okay? Of course, bereavement can impact on many things, such as stress, concentration, our ability to make good decisions, sleep, many other things, which, if compromised, could have a negative impact on an individual's personal safety, and of course then also the safety of others. Okay, now this is probably going to be more relevant for individuals required to work with things like heavy or dangerous equipment, vehicles, administering medication, and so on. Okay, so employers must remember that they have a duty of care, and there is a requirement to be somewhat proactive with that. It may well be that you have an employee who's not wanting to open up about this sort of thing, who is carrying on, but we need to perhaps look at getting involved and consider whether it's appropriate even to conduct a risk assessment, or to put some form of temporary safeguards in place to protect that person and others. And as we always do in HR, we've also got to think generally about our existing obligations and fairness, across the board. So when you are deciding how much bereavement leave to offer to anybody, employers have got to consider, the policy, if there is one. To be honest, I don't typically come across many policies for things like this, but if there is something, we've got to adhere to it. The contract, if you do have any contractual clauses that might relate to leave such as this, we of course need to adhere to those. Remember that if you have handbooks which have contractual elements, that is also something we need to refer to. And custom and practice, which is probably the factor that plays a bigger part when it comes to bereavement leave anyway, as it's something we do tend to review and implement and offer to people on a case-by-case basis. So if you are unfortunate enough to have had someone who needs to take bereavement leave in the past, then do always keep in mind what they were offered and use this as a bar when considering what to offer to the next person. If you haven't had a situation like that, then remember that what you offer now may set the precedent for what the next person is offered in future. But we always say these things tentatively because, of course, bereavement is such a unique experience for people given various factors. Just in terms of personal preference, some people might actually prefer to be in work. It may be that subsequently they decide that that's not right for them anymore, but it really does have to be on a case-by-case basis. But always bear in mind your custom and practice as a bar, so that we are being fair to everybody in the minimum that we offer. And as I say, individual circumstances is important, but particularly bearing in mind any of those areas that I've discussed previously as well, as factors that might mean it's fair to vary what you offer. So, for example, religious practice, or anybody who is struggling with a disability. So we've got an awareness of what bereavement leave is going to look like in the future, at least for parents, and hopefully refreshed you on some important topics that we need to be thinking about when offering any sort of bereavement leave, currently. And of course, anything we offer currently is above the minimum standards of the law, except where I've mentioned things like the Equality Act and things. But let's just have a quick look at how we would go about implementing any new practices and policies based on, you know, the new minimum obligations that are going to be coming into force. So it means we are now moving slightly into the topic of discussing changes to terms and conditions. And I imagine if you've sought HR advice before, or if this is something that you do, that you're probably aware that usually if we want to look at changing terms and conditions, it's something that has to be done with the agreement of the employee, or we have to have an extremely robust business rationale before we can even really contemplate doing it fairly and lawfully. Now, there are certain situations in which we can just implement a change fairly without doing either of those things. And one such situation is when there is what's called an implied right. It's one of pretty much the only situations really, but an implied right will arise when there is a change in law which is more favourable than what is currently offered by the employer. Okay, and that is simply because there is now a new legal obligation that we have to adhere to, because otherwise we would be breaking that law. Okay, but it is only the case when what the law that is coming into effect introduces is more than what we currently offer. Okay, in that situation, you can and should implement the new legal requirements with effect from the date that that law comes into effect. Okay, now what this means is that if you're looking at what I've said the government is bringing in and you think, yep, for us that does enhance our current offering, you will be required to implement this as a minimum from the enforcement date. Okay, now, yes, that act is passed, so yes, it is currently law, but as I said, we are still waiting for those regulations to define some of the finer points, and that regulation will also give us an enforcement date. And as I mentioned before, we're expecting that to be April 2020, but it could be sooner. Okay. Now, when you are bringing in these new practices, you might even bring it in as a policy. You know, this is potentially going to entail you having to review any existing policies that you might have. Okay, you might also need to review your handbooks that you have, if that refers to any type of compassionate or bereavement leave as well, or anything related. And it may also entail you thinking about staff communication to raise awareness. And I imagine this is something that many employers, well, it's certainly something I would advise all employers to consider as a minimum. Now, even though you wouldn't have to necessarily communicate it, it's always going to be better that employees have an awareness that there is a provision for something like this, you know, before the tragic event occurs, so that they are not having to contact you, you know, feeling like they're going to have to ask you to grant them that leave. You know, certainly if you've perhaps got the provisions available somewhere on like a company intranet or something that they can perhaps access remotely, you know, that sort of situation is ideal. But as a minimum, you know, perhaps an email or a letter to let them know that this is a new type of leave and arrangement that is available if anybody should ever have to use it. And that brings us to the end of today's session. So if you do have any questions that you haven't yet sent over to us, then please do send them through. You will get a follow-up reminder, which is another opportunity for you to send over any questions to myself. But please get in touch, and I'll be very happy to get back to you with anything that you want to ask about the things we've discussed.